Hey, good afternoon, y'all. Welcome back to our review for the Texas real estate exam and for the national questions. Excuse the delay. So on this video today, we're going to review national questions for all 50 states and the answers, and also some Texas state questions. I'll do the national first in case there are some of you that are from other states, and those that are from Texas can stay till the end. All right. So what's up, everybody? This is Wednesday evening, and this is Wild Lily Handy coming to you from San Antonio, Texas with YouTube AgentPrep to help you pass your real estate exam, national and also Texas state. So let's get started where we left off on Saturday. So again, we're using this book, Texas Real Estate Sales Exam. Okay, it's an old book, but it's excellent, as I keep saying, because the national questions are still the same. A few of the state questions for Texas have changed, but very few. Okay, students continue to tell me it's the best book that has helped them pass the exam. And that's why I keep focusing on this book. I've not found one exactly like it, but I'm still looking. All right. And again, the reason why I love this book, for those of you who just came on, this is the Texas Real Estate Sales Exam Guide, which is for national and state questions, and vocabulary, has a review, a refresher course, math review, and a lot of the glossary, which is the vocabulary. It's got 4 exams of 180 questions. 110 questions. The first 80 are national questions, applies to all 50 states, and the last 30 are state. In today's exam in Texas, okay, realize this, in Texas, we have 125 questions, 85 national and 40 state. 85 national and 40 state. That's 125 questions, and you must get a 70 in order to pass. Other states, they have it all in one exam. It combines both national and state. So if you're in another state other than Texas, you'll want to have your own prep book for your particular state, as I only do Texas, or you can go to other services and pay for a year service or monthly. But there are a lot of programs online that are free. And, Quizlet, there's another gentleman, Prep Agent, who's been doing it for years. And he does some videos for other states. But in order to get the whole quality of it, you'll have to buy his course. Okay, so let me put my phone on mute here so that we will not be interrupted. Okay, and today I'm going to create the screen a little bit larger and take myself off the screen to kind of help all of you that might be on your cell phone and provide you with a larger screen. Okay, so let me do that. Oh, okay. Well, it does a small one of me. Looks good. Excited for today's class. So who is that? Let me get the Facebook up. I do have it up, but I need to refresh the screen in order to be able to see who's on here. And because if you have not given StreamYard Facebook permission to post your name on StreamYard, I get to see you like this. Okay, just says hello, a Facebook user, okay, or another Facebook user. So you need to go, please, to StreamYard.com/Facebook. Okay, and give Facebook permission to post your name. You see how it posts my name, YouTube AgentPrep. Okay, so once you give Facebook permission by going to StreamYard.com/Facebook, It's a real quick thing to do. You can do it while we're on class, okay? And that way I'll be able to see your name, and so will everybody else. So why don't you go ahead and do that while I'm getting the screens going. Hi, Vladimir. Good afternoon. Yes, and it's an awesome afternoon, even though it was a cool one, right? So we're continuing with question number, 51? Yeah, we did up to question 50 on Saturday. We continue with question 51 and that today. Way I'll be able to see. So hold on with the noise on the back. And for those of you who have the book, you can follow with the book, okay? I wrote it in the remarks, and it's on page 38 for the National. Okay, and that's that huge book of 287 pages. All right, so who is it? Lauda. Hi, Lauda, Holly. Thanks for joining us. So I got to see your name on Facebook because I got that going. And so why is this not letting me enlarge it? Bear with me, you guys. It takes me a little time to prepare 3 different websites. Doesn't let me do it in advance. It's unfortunate. I wish it did. All right. So let's get started. These are national questions, okay? Question number 51. And let me enlarge that. Well, welcome back to my channel. So today we're going to okay, see here. Hold on, that was the other Facebook page. And since I've got so many things going on, national question. It's and I've got my okay, I think I have it together now. All right. Under the Truth in Lending Act, which is called TILA, okay, that is the acronym, the cost of credit extended must be expressed. Okay, so Truth in Lending Act, that deals with lenders. Hi, Jean. Thank you for joining us. So Truth in Lending Act, TILA, right? That's the acronym. So the cost of credit extended must be expressed how? So the lender, when they're marketing, when they're advertising in any kind of media, newspaper, books, magazines, okay, social media, they must disclose what? Due to the Truth in Lending Act. The cost of credit extended must be expressed as what? A, the discount rate, B, the prime interest rate, C, the actual percentage rate, or D, the annual percentage rate. Okay, I'll give you time to type in the question number and answer in the chat box. Hi, Jen. Thank you for joining us. I'm hoping that a lot of you are going to be taking your exam soon. Hey, Sammy. Okay, let's see. I've got DDD so far. Okay, so far. And hi, Iris. Okay, yes, the answer is D, the annual percentage rate. It is different. Hi, Lisbeth. No, Lisbeth, sorry. It is D, the annual percentage rate. So, and the annual percentage rate, it was actually shows, hi, Laura, which is what shows the total cost, okay, of lending, including some of the closing costs. Okay, so not only the loan amount, okay, the cost of the loan, but also the cost of the closing that are allowed, okay, will be added to the loan amount and then extended for the 30 years, okay, so amortized, and they come up with the annual percentage rate. The actual percentage rate is the interest. Let's say right now interest rates have gone up to maybe 4%. So it'll be 4%, but the annual percentage rate, which includes some of the cost of closing, will be maybe 4.125. Okay. So that's the cost of credit extended. So it is the whole cost of credit. Okay. Not just the actual interest rate of the loan. Got it? Okay. You meant D. All right. So the answer was 51D, or is 51D. Okay. Oops, I typed it on the wrong one. Let's see here. All right, number 52. I think I can enlarge the screen a little bit more. What method of foreclosure is used in a deed of trust mortgage lien? Okay, remember, there's two different types of mortgages. In about 50% of the states, it's a deed of trust. In the other states, it's called a mortgage. Each of those types of mortgage have a different type of foreclosure. Okay, and every state has their own foreclosure laws. So in Texas, we use the deed of trust mortgage, and that is from central states to the west. From central to the east, they use what is called a mortgage. So with a deed of trust mortgage, what type of foreclosure method is used? Is it A, non-judicial power of sale, B, judicial court-ordered sale, C, sheriff sale at the courthouse, or D, deed in lieu of accepted by lender? So again, I stress definitions. Okay, definitions. See, I'm going to put myself in a little picture. You can see I have new lighting in the back. How do you like that purple and pinkish, huh? It's for streaming. Lots of more lights. All right, let's see. So far, I've got Jean says C. And Jean, I'm going to say try again. Okay, a foreclosure is not a sheriff's sale, even though sometimes it'll be the sheriff that's presenting it. It could be another realtor that has been hired to present foreclosures at the courthouse steps. And but it's usually the trustee or someone else that is hired in order to do and announce the foreclosures. But it's not a sheriff's sale. Okay, I can tell you this, it's not C or D. All right, so right away. So there's either non-judicial power of sale or judicial court ordered sale. The two different types of foreclosures are non-judicial and judicial. Okay. So try again, okay? I'm going to have you keep trying again and trying again until you get it right. It's not C or D, okay? And yes, Iris, it is A. In Texas, with a deed of trust mortgage or other states, it is a non-judicial. So in a deed of trust, that deed of trust has a trustor, has three members, a trustor, a trustee, and the beneficiary. The beneficiary is the lender, and the trustee, okay, gets a copy of the deed of trust so that they know exactly what steps to take when they're doing a foreclosure for the lender if for some reason the trustor defaults. So anytime there's a trust, there are at least three parties: trustor, which is the borrower; trustee, which is the person that is hired by the lender to represent them and follows through with the deed of trust. So that deed of trust is entrusted onto the trustee, and the trustee signs documents like they have a power of attorney. And the beneficiary is the lender or the bank, whoever the bank is. So the answer is A. So deed of trust, non-judicial. Judicial, mortgage. So let's remember it this way. MJ, mortgage, judge. MJ, mortgage, judicial. Deed of trust, non. So let's see. Okay. So how about deed of trust? You don't trust anybody. Non-trusting. Okay. Don't trust. So deed of trust, non-judicial, non-judge, no judge. Judicial, mortgage, MJ. So if you remember MJ for mortgage, it's a judicial, means they've got to go to court and get the court order by the judge. So MJ, okay? With a mortgage, it's judicial. With a deed of trust, it is non-judicial. Okay, so Vladimir says, okay, I was just about to ask why. Thank you. Got it. So that was 52A. And if you ever see me typing the wrong answer, please let me know. Oh, darn, I have the wrong one. So 52A. Got it? Yeah, I like to remember things by relating letters, or like when I meet a whole bunch of people, and if I meet Ember, Jane, John, I'll think to myself, okay, AJJ, and I repeat it, Ember, James, John, and repeat it. So AJJ. It's a little bit easier for me to remember people's names. Okay. So, find little tricks like that to remember certain things, certain answers, numbers. Okay, hold on, you guys. I've got the wrong video going on one of the Facebook pages. I have a prior one. Let's see. So broadcasting right now. Bear with me. So read number 53, okay? And then think of the answer, and then I'll read it and explain it. Okay, there's me with the red hat or the red cap. Okay, so you're going to hear a little bit of sound in the background. All right. So 53, if a seller receives multiple offers in this market right now, we have multiple offers. Okay. Every listing that I put on the market, I get multiple offers. It gives a chance for the seller to maybe get a higher price. So if a seller receives multiple offers, what happens? A, they must consider the offers in the order which they were received. B, they must negotiate the first offer before they can see the others. C, they may accept any one of them regardless of when it was received in time. And D, they must disclose to all parties the existence of other offers. So which one is the most accurate answer? Type it in the chat box, either on Facebook or our YouTube. I'm trying to see if I can get you all to shift to YouTube, okay? And then I may not have to stream it to so many different media, but it's okay. And that way I can get your help and subscribe to my YouTube channel. Okay. That motivates me to create more videos. Okay. And help you pass your exams, and then additional ones that I'm creating to help you get your business started. Like what happens after you pass the exam, right? Okay. So let's see. Godric. Hi, Godric. Says A, offers, orders, and let me see. Orders and offers must always be countersigned with consideration. I'd reconsider, Kodrick, graphed it. Okay, go back and choose a different answer. Okay, it is not A. So so think of yourself as being the seller. All these offers are coming in. Wouldn't it be nice to wait for all of them to come in, especially if they're happening within the first couple days, and see which one is the best offer? Right? Wouldn't that be a plus to you? It would be a plus to all sellers. So if a bank has a property listed, the bank is going to look at a whole bunch of offers, no matter what order they come in. They're going to say by such and such date, we will review all the offers and make a decision. Doesn't matter in what order they came in, as long as they review them. And we as agents, we must present all offers, right? That one's a must. Okay, so let's see. So Sammy, Laura, and do I have two Lauras? I have a Laura. Oh, you changed your name maybe, or two people with the same name. So CC, yes, they must review all offers. What about duffers? I don't know what duffers are. Okay. If you're not a student, I don't know what a duffer is. Okay, so all offers. So the seller may accept any one of them regardless of when it was received in time. Okay, it could have been the last offer they received. They're going to review them all, and then they'll review together with the realtor, what are the terms of the offer? Is it cash? What is it, a loan? Is it a conventional loan, or is it an FHA, a VA, which require, a better home in better conditions, or everything repaired? What is the closing date? What are they asking for? What are they not asking for? When a seller has multiple offers, they want to look at the cleanest offer with the quickest date. The highest offer is not always the best. However, yes, we all want the best price, right? However, the best price may have a closing date 45 days later, and the seller might say, hey, man, I don't want to wait 45 days. I want it now. Okay. So then they'll accept one maybe for a little bit less, yet higher price. And some will go ahead and accept the highest offer, even though it doesn't have the best terms. And in this market, sometimes offers fall. Okay. In fact, in all times, offers can fall. And it's a good thing when there's multiple offers, because if one of them falls, there's always the other realtors will say, hey, they re-put the offer in. Okay. So the answer, that was a long explanation, but that's so that you understand, okay, for the exam and how to think about these. Oops. So 53C, very good. So y'all go ahead and participate. There are a lot of you here, and this is a time to participate, and let me help you understand it and get it right. Okay. All right. Number 54. So if I see you have the wrong answer, I'm going to say, try again. Do it again, not try it. Do it again. Okay. All right. Number 54. The entity that loses ownership through a deed of trust foreclosure is whom? The lender, B, the beneficiary, C, the mortgagee, or D, the mortgagor. Okay, I said trustor and trustee, but there are other names also when there's a deed of trust. That's the never mind. Okay, so is it the lender? So who loses ownership through the foreclosure with a deed of trust? The lender, the beneficiary, the mortgagee, or the mortgagor? Okay, a little bit ago, I let you know who the beneficiary is, so you would know. Okay. Okay, so far I've got Jen saying D, the mortgagor. You got to remember your ORs and EEs. One's the giver, one's the receiver. Right? Okay, so I've got D, D, C, D. Lisbeth, I'm going to have you do it again. It is not C. In this case, the EE is the receiver. Okay, the receiver is receiving the collateral or the lien as collateral. Okay, the answer is D, the mortgage or. So when you think of OR and EE, right, the OR is the giver, the vendor, the trustor, the landlord, then what else? So anything that's with an OR, the EE is receiving, right? So it's the lessee. The lessee receives an apartment to live in, right? Also the lessor and the lessee. So the lessor is the landlord, right? And in this case, the mortgagor is the borrower. They're the ones that borrowed money, but they're giving back to the lender the deed of trust or the lien, okay, the collateral, okay, the right to foreclose on them if they don't follow through with making their payments, even if they don't get their insurance or the homeowner's insurance, okay, or pay their taxes, that lender can foreclose on them. So it's a deed of trust. So it is a, what type of foreclosure? Non-judicial. Remember, it's not an MJ, mortgage judicial, mortgage judge. Okay, this is a deed of trust. So it's a non-judicial. Let's see, how could you remember so the other one I said MJ, this would be ND or DN. Let's see if we come up with some other acronym, okay, for remembering. So as long as you remember MJ, mortgage judicial, you'll remember that the other one is the non-judicial, right? So 54D, right? Okay. All right, 55. Any questions? Hey, if you see any weird stuff on here, disregard it. There are people who are on YouTube, okay, and end up typing in crazy stuff. So ignore them. All right, number 55. So anyone who came in late, we're doing national questions, okay, on exam number 1 of this book, Texas Real Estate Sales Exam. And you can download it from our Facebook group, AgentPrep, or you can send me your email and I will email it to you. But I need to have your name and email before I send anything out. I'm not giving things out anymore unless people commit to filling out the questions that I request. All right, 55. One advantage of condominium ownership over cooperative ownership is that so condominium, hi Jennifer, thanks for joining us. So condominium versus cooperative ownership. Here's something to study on your glossary. So hi Ricky. So condominium owners pay no maintenance fees. B, condominium owners can mortgage their units individually. C, cooperative owners have no choice in which unit they occupy. Or D, there is basically no difference in the two forms of ownership. So cooperative versus condominium. You know, cooperative can be like a timeshare where you only use it for so many weeks out of the year. And those people, realtors can't sell timeshare. Okay. Sometimes there's a question that says, can realtors sell timeshares? Yes. Okay. Because they are filling out contracts, okay, legal documents. And so when you go to all these beautiful blue water places, resorts, right, they have, timeshares, cooperatives. Okay, so far I've got BBB. Doing good. Come on, there's a whole bunch of you on here. Go ahead and type your answer. So BBB, anybody else? Don't be shy, okay? This is the time to practice. Hey, very good. Y'all are on a roll. Yes, it is B. Condominium owners can mortgage their units individually. In a condominium, we own the unit inside the walls and we insure whatever is inside the walls. The HOA insures the outside, the driveways, the building, the roof, anything on the outside. Well, with the exception of the AC, right? The AC compressor is outside. That belongs to the owners. So any common areas are taken care of by the HOA, by the HOA dues that we pay. And some of those HOA dues cover water, sewer, the gate, trash, pickup, that type of thing. Some HOAs are real expensive, others are not. I bought a condo and the HOA is really nice. Covers water and sewer, and I have access to 3 swimming pools, and it's gated. Plus it has a 1-car garage, which not all of them have. So there is a difference, okay? So if you weren't sure about it, go back and study your definitions, your glossary. Okay, 56. Unauthorized disturbance. Oh, let me show the answer. Unauthorized disturbance of established wetlands may result in what? Okay, so we think of wetlands. There's different ways to think of wetlands. Like wetlands or lands that are protected, right? Other wetlands are agricultural land that has irrigation. I learned that because I represented a lot of sellers that sold agriculture. So dry land means it doesn't have any irrigation. It depends on the rain. Wetland means they have irrigation. Okay. But other type of wetland is land that could be protected, right? So unauthorized disturbance of established wetlands may result in a suit for condemnation, B, justice of the peace court fines, C, county court civil actions, or D, federal felony charges. So let's say you're in Florida and they have swamps, right? Or in Georgia or some of those states. And those swamps are protected. They're considered wetlands, right? In California, they've got what, alligators? And they've actually found some sharks on some of them, even though sharks are saltwater. Okay, let's see. I've got 50. So far only 56A. So come on, give more of you a chance to do that. No. I will ask all of you to do it again. Well, let's see. I've got a D here, okay? So A, D, A. Those of you that answered A, it is not A. Okay, what is condemnation? What does condemnation go together with? Eminent domain, right? Well, they're not taking over land from an owner. That's what eminent domain. Oh, that's right. Bull sharks are fresh and salt water. Thank you for that, Sammy. I'll stay away from those freshwater areas, okay? Because they say bull sharks are mean, right? Yeah, eminent domain goes together with condemnation, so it's not A. So select another answer. So are wetlands local, state, federal? What kind of protection do they have? So if you have endangered species, those laws are what? National and worldwide, right? Okay, those of you that have A and C, it's not accurate. Okay, it is not suit for condemnation and it is not county court civil actions. Okay, disturbing established wetlands, okay, is federal. It's a federal felony nationwide, okay? And there's also others worldwide, but here in the US, it's a federal felony. Okay, so those of you, it's not in the little county because, you know, a lot of counties don't have wetlands, but if they did, it goes to, it's protected by federal law. So 56D. And so that falls, according to the answer, it falls under the Federal Clean Water Act. Okay. So if I'm going to do some state, I need to go a little bit faster. We started at what, 51? 1, 2, 3, 4, 5, 6. We've done 6 questions. Okay, 57. The form of ownership that would give an investor the greatest flexibility when selling his or her interest would be what? Okay, the form of ownership. I'll tell you this, there are 4 types of ownership, and that is 4 types of ownerships to own property. Okay, so, and if you know the 4, then you can eliminate some of these answers right away. So what ownership, which form of ownership gives an investor the greatest flexibility when selling their interest? Would be A, general partnership, D, ownership in severalty, C, joint tenancy, or D, a limited partnership. So which form of ownership gives an investor the greatest flexibility? So, okay, so far I've got 57B. Come on, y'all. Lots of you on here. So let's get to it. Type your answers down in the chat box, whether you're on Facebook or on YouTube. And if you're on YouTube, hey, please subscribe to my YouTube channel. Send me some love, some support. Help me and motivate me to create more videos because it is a challenge. But it's the way of today for learning. Okay, it's the best place to learn other than the other social media. YouTube is a social media for learning. Okay, so far I've got B, 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 A, D. Okay, it is not D. And it is not A. Okay. 4 types of ownership are severalty, tenants in common, joint tenancy, and tenants by the entirety. In Texas, it's the 4th one is community property for married people. Hi, Gloria de la Fuente. See who else has come on here. All right. The answer is B, ownership and severalty. So if a person is a single entity, see, a limited partnership would fall under, it's an entity. So ownership and severalty can be one person or an entity. Okay. So an entity could be a partnership, a corporation, and one person signs. Okay, because they usually have board members or someone, an officer that's going to do the signing. So partnership fall under severalty. There's one person that makes the greatest decision, flexibility. They don't have to lean on anybody else. Although if they're a partnership and it falls under severalty, of course, there's more than one member. But for individual investors, okay, corporations do invest, partnerships do invest. However, they are considered one, an entity of one. And that is owner in severalty. Okay. Hey, Gloria, when you get a chance, go to streamyard.com/Facebook. And give Facebook permission to post your name on StreamYard because I am streaming with StreamYard. Okay. All right. So 57B. All right. Number 58. Okay, here's a math problem. What is the indicated value of a home if the others in the neighborhood sold recently for between $160,000 and $167,000? And the subject house has a pool. The subject house is the actual house that is being sold. Okay, valued at $8,000. So the pool has a value of $8,000 according to the appraiser that the other homes do not have. So what is the indicated value of a home if the others in the neighborhood sold recently between 160 and 167? But all those homes that sold did not have a pool. This home has a pool, which adds a value of 8,000. So what becomes the new range of an indicated value to price the property? I gave you a keyword, so you would eliminate two answers right away. Type your answer on the chat box, either on Facebook or on YouTube. And I'll see your answers. Nobody taking a risk? Oh, you haven't studied your math. Okay, well, that makes some sense. However, so if you have a price range of normal homes without a pool from 160 to 167,000, and the subject property has a pool with $8,000, what would that do to the price? You'd be adding 8,000 to something. And let's see, it's not D. Okay, I'll tell you that much. It's not D. So if you have homes in your neighborhood that sold for 160, 167, but this one has a pool. Wouldn't you be adding 8,000 to the 160 and 8,000 to the 167? That would be the new price range for this particular home. Yes, right? So it says the indicated value of a home. What is the indicated value of a home if the others in the same neighborhood sold recently within the last 3 or 6 months, depending on how fast the market is moving? If they sold between 160 and 167 and the subject property has a pool valued with 8,000 that the others do not have. So the others don't have a pool. So in order to bring it up to this home, they'd have to add a pool worth 8,000. So that would bring their homes up to what? 168 and 175. That would be the new price range. So the answer is 158. I'm sorry, not 158. 58C. Okay. Got it? Got it? You know what? The answer ends up showing so many times because I'm posting it also on Facebook. Oh, am I pasting it on the wrong one? No, not pasting, typing it. When I tape it on the Facebook group, it also posts it on YouTube. Okay. No, it doesn't. It posts it on StreamYard. Okay. So number 59. Y'all get that? Did you get the explanation and understand why it's C, 168 to 175? We added 8,000 to 160 and 8,000 to 167. That makes it the new price range because it has an $8,000 pool. Per the appraiser, okay? Oops. Shoot. 59. Dang. I'm thinking price range and I'm thinking, yes, okay, you all get it. Got it, got it. All right, 69, 59, 59. Commercial banks prefer to make short-term loans like construction loans and 90-day business loans. Commercial banks, okay, they prefer to make short-term loans. They don't want to keep their money tied up very long because there's a lot of construction going on, right? So short-term loans and 90 days business loans. The reason for their preference is what? A, the source of their funds is primarily from CDs, certificate of deposits. The source of their funds is primarily from savings accounts. C, the source of their funds is primarily from checking accounts. Or D, the source of their funds is primarily from issuing bonds. So which one may it be? Oh man. All right, so far, nobody answering yet. Okay. So why do commercial banks prefer to do short-term loans and 90-day business loans? Construction loans, I'm sorry, short-term construction loans. So they're loaning money to malls, business strips, offices, anything that is a construction, okay, a commercial property. It could be a multiplex unit, anything greater than 4 units, right? Because 1 to 4 is residential. Anything over 4 units is considered commercial, multi-unit, right? And no, 59 is not A. Certificates of deposit usually can't be liquidated fast enough. Some of those certificates of deposits are, 6 months, 9 months, 12 months. And so these are short term and up to 90 days business loans. So it's not A. So type another answer. So let's see. So far, I have A and B, right? Okay, come on, y'all. I'm going to tell you also, it is not B. It's not A and it's not B. So do it again. So that eliminates two answers. It's either C or D. C or D. C or D. Not a C, D, but C or D. Got it? Yes, I'm glad y'all are thinking about it. It's a must think. This one is a challenging one, even for me, okay? Oh, pardon me. Yes, let me reduce it a little bit more. So it's not CDs. It's not primarily from savings account. So it's either primarily from checking account or primarily from issuing bonds. Okay, the answer is C. Okay, the source of their funds is primarily from checking accounts. And the reason for that is since a bank's funds are by definition short term, that is from checking accounts, also known as demand deposits. The banks prefer to make short term loans. So commercial loans are typically from checking accounts known as demand deposits. So the answer is 59C. Okay, last question of the night for national questions. Somebody asked me today if I was doing state or national. And since I have a lot of students also that are national students, that's why I'm doing both. All right, number 60. Okay, you get that? So commercial banks have predominantly checking accounts, also known as demand deposits. Okay. All right, number 60. What is the difference between competitive market analysis and comparative? Compete versus compare market analysis. So some properties are competing with others. Some properties are a comparable of what already happened, right? We compete today. We compare with, it could be something in the past, something in the future. I won't tell you too much. So what's the difference between competitive and comparative? They both stand for CMA. However, they're either A, sold comparables used, B, amenity differences between the comparables, C, adjustments for time of sale, such as location and property condition, or D, properties currently for sale in the same market area. What is the difference between competitive? So what does competitive market analysis have? What kind of properties? And what kind of properties does comparative market analysis have? CMA, CMA. You probably didn't think there were two different ones, right? So we show a seller competitive market analysis. We show a buyer comparative market analysis. Come on, lots and lots of you on here. Type your answer. Come on, try it. So competitive would mean, it has certain types of properties that are on the market. Comparative is only going to have one type of property on it. So the different types of properties are active, pending, and sold. Okay. So does competitive have active, pending, solds? Or does it have only actives and solds? Does comparative have sold, active, and pending? So what does each one of them have? And one of them only has one item, one type of property. The other one has 3 types of property on it. Okay, so far I have an answer of D. Yes, it is a challenging one. Sammy, no, it's not A, because both competitive and comparative have sold. So I pretty much gave you an answer to that, because I said one of them only has one type of property on it. So try it again. Do it again. Not try it. Do it. Do it. In our world, we say we don't try, we do. Oops. Don't try, do. Okay, I'm getting more DDDs. That's correct. So a comparative property only has sold. Okay, a competitive has actives and sold, and some of us include pending. Reason for that is when we're talking with a seller, we want to let them know what other homes are on the market that are similar to theirs, currently priced. What homes similar to theirs have an offer pending? What homes similar to theirs have sold? Right? So we don't show them just sold, because then they're going to say, well, hey, you know what? My neighbor over there and over there, their properties are listed, much higher than mine, and mine is much better than theirs. Well, that's the competitor. Do they have an offer? No. How long have they been on the market? Oh, 60 days. Well, 60 days is too long for now. Okay. Properties that are good, nice neighborhoods, in good condition, priced right, they're selling like that. Okay. So we want to show them what's active, their competitors, they're pending, to let them know, hey, this one got an offer in 1 day, in 2 days. Okay. And if you want to price yours 10,000 over and it's almost identical, you're going to be overpriced. So that's how we help them come down to a realistic price, because we all think our properties are worth more, including realtors, okay, and brokers, okay, because I also own properties and am an investor. So the answer is 6D, okay? The comparable is used to help buyers, and we advise them on a price range to offer based on properties that just sold recently within the last 6 months, and typically in this market within the last month and last 3 months. Okay. So it depends who you're working with, buyer or seller. I mean, you can show the buyer a competitive, okay, in case they want to offer really low, okay, low ballers. Investors will low ball, and but not in this market, because today's market, there are tons of investors buying property, and so there's a lot of competition on fixer-uppers. Okay. All right. So that's it for the national questions for tonight. We will continue with state questions. So any questions on that? So how did you like my giving you an opportunity to keep changing your answers until you get it right? Now, I can only give you so many hints, right? Now, were most of you able to see it much better since I did a larger screen and show myself a little bit smaller? I'm trying to minimize another screen. Okay, we are starting. Gosh, my screen doesn't want to adjust here. Okay, here we go. Okay, what are we starting with today on state? Oh, we're starting with exam number 3. Okay, on page 25. I'm sorry, page 225. So we're on exam 3. Why are we on exam 3? Because there are only 30 state questions per exam. And there are 80 national questions. So of course it takes us longer to go through the national exam. 200. All right. So anyone that's here from another state, you're welcome to state, okay, and get an idea of how state questions, work. Just realize that these are for Texas and not for your particular state. So 225 to 35. Oops. All right. So let's get with it. Oh, hold on. Let me take a sip. Oh, man, I'm drooling. Yes, you love it. Okay. So, okay, I'm going to minimize my screen even more and say if that helps anymore. Well, it doesn't enlarge the screen much, right? So now I eliminated my face from the screen. I mean, you don't really need to see my face, but it kind of helps on YouTube that people know who you are or who we are. Okay, going once, going twice, gone. Question 81, exam number 3, state on this book, Texas Real Estate Sales Exam, 4th edition. It is from 2006. So a few of the answers are late. Are outdated, but very few. Okay. Right. All right, 81. What law governs the relationship between real estate licensee and a client? A, law of agency, B, clientele act, C, statute of limitations, or D, deceptive trade act. Okay, so far I already have A's. People were ahead of me, which is good. All right, A. Okay. Come on, more of you. Go ahead, type your answer, either on Facebook or YouTube, and it'll show up here on StreamYard. All right. Yes, the answer is A. There is a whole body of law and regulations. Okay, the law of agency. You have a whole course on that, or at least in Texas, right? Because we have 180 hours that we take. And that address a relationship between agents and their clients. The sum total of the various legal provisions that address the agency relationship is known collectively as the law of agency. Okay. I was reading the answer to an extent just to give you the, oops, typed it in the wrong place. All right, number 82. Okay, this is the longer one, so I need to minimize. I need to go smaller. All right, number 82. Each resident broker must maintain a fixed office within Texas. Okay, this changed Okay, this is one of the outdated questions. That's why I changed the color. And actually, this just changed last year. What must a broker do when he or she wants to maintain multiple offices? A, register each office location with the county clerk where the assumed name form is filled. B, register each office location with the licensing department of the Texas Real Estate Commission. C, obtain a branch office license for each location. Or D, employ a broker manager for each location. Didn't get the whole highlight going there. So anyway, this question is outdated. So in today, so at this point, at this question, okay, it required to register each location with the licensing department of the Texas Real Estate Commission. Okay, they still have to register it, but they don't have to register it with, they don't have to obtain a new branch office license for each location. Okay, that was the correct answer before, C. Okay, so that no longer has to be done. So disregard this question. Okay, they still have to register with TREC. However, they don't require to obtain a branch office license for every single location. So if there's a broker that has multiple locations, one license suffice, and they can post that same license in the different locations. Okay, so 82B, you know, I would say register each office with TREC. Okay, but they can, they don't have to be issued a new license. Well, yeah, so TREC has to know where we're hanging our license, okay? So when you're doing this question, if you're doing it on the book, just disregard this question. C is no longer correct. No longer does a branch office have to have a different license, okay? All right, 83. So of course, in your copy, it's not going to be highlighted if you download it from my Facebook group or you find it in Google. All right, 83. A real estate broker routinely advises her clients. Okay, a real estate broker, not an agent. Okay, a broker. In Texas, we have brokers and agents. Other states, they have broker and principal broker. Okay, so and the broker would be like an agent here in Texas. The principal broker would be like a broker. Okay, but we're dealing with Texas. So a real estate broker routinely advises her clients to strike the provision in the sales contract referring to a suit for specific performance. She also adds to the special provisions paragraph that if the buyer's inspection is unsatisfactory, the buyer may terminate the contract. This broker is doing what? A, performing her fiduciary duties to her clients. B, giving her clients good advice. C, practicing law. Or D, practicing brokerage. So the question would be, can you scratch things out of a contract? Type your answer, the number and the answer. You're right, Iris. We cannot be scratching things out of a contract. Now, if it is an attorney, yes, because they're attorneys, right? But not us as brokers or agents. Here they're talking about a broker. Okay, so brokers cannot strike out any provision in a sales contract and then put something in the special provisions if there is a promulgated contract or form for it. Okay, so with the comment that buyer may terminate the contract, there are provisions with that within the contract as to when the buyer can terminate a contract. Sammy, A is not correct. So think again. I just said we cannot, as a broker nor an agent, strike any information from the contract. No provisions. We are not realtors. I'm sorry. We are not attorneys. Okay, we don't practice law. And them doing that, hi Susie Q, them doing it is practicing law. Big no, 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 no. We're not an attorney. Now, if we were a licensed attorney and we also have a real estate license, we may be able to do that. However, could it be a conflict of interest? Yes. So the answer is C. Okay, so the answer says, unless this broker is also a licensed attorney, she is in violation of the Real Estate License Act. A broker has it. Okay, so if she's a real estate license attorney, they'd be able to do that. Okay, even though they're also a broker. So a broker has a duty to advise a client, okay, regarding any facts or business detailing involving the transaction, but not give legal advice. To do that, we refer them out to an attorney. Okay, we do not give legal advice. We are realtors and brokers. We deal with showing properties and writing the blank, filling the blanks in the contracts. We let the attorneys do the legal work, right? We also don't explain the title commitment or the warranty deed and tell people what is correct and what is not correct, or I should say our clients, right? We don't do that. We let the experts do what they are an expert at. Title company, experts on title insurance, and escrow officers, experts on closing, and they're a third party, okay, that is not involved with any of the parties. They're getting paid from both seller and buyer to close a transaction. So they're a non-participating they're a third party that is not involved with one or the other and cannot give advice. Okay, the escrow company. Okay, number 84. So very good for those of you who had an answer C. The Texas Real Estate Broker Lawyer Committee, is made up of what? Of whom? A, 6 real estate brokers and 6 lawyers appointed by the governor. B, 6 real estate brokers appointed by TREC, 6 lawyers appointed by the president of the state bar, and 1 public member appointed by the governor. C, 6 real estate brokers, 3 lawyers, and 3 public members appointed by the governor. So remember, who writes the contracts? Okay, we've got to have some legal people in there, right? D, 6 real estate brokers, 6 lawyers, and 1 public member, all appointed by the governor. So I will say that the Texas Real Estate Broker Committee is 13 members, okay? So by knowing 13 members, that narrowed it down to 2 of the questions on here are correct. All right, so far I have an answer of B. Okay. And B, Insuk Smith. B, oh, D. Okay, those of you who answered D, guess again. And Insuk, when you answer the question, would you please type the question number? Thank you. So it's 13 members, okay? But you've got some that are brokers, some that are attorneys, and 1 public person. Who appoints each of those? So who, okay, who's the other person that did D? Facebook user. Okay, I can't tell who the other person. Oh, Gloria. Okay, it is not D. Okay, so you changed it to B. All right, that looks good. Yes, the answer is B. It is 6 brokers appointed by TREC, Texas Real Estate Commission, 6 lawyers appointed by the president of the state bar, right? That's where they get their license, and 1 public member appointed by the governor. So each respective organization, okay, selects or appoints theirs. Brokers, TREC. And they have to be brokers, not just realtors. They have to have a lot of experience and know all the different types of contracts. Attorneys, right? They write laws. So this committee is who writes all the promulgated contracts here in Texas. So what was it? 84B. That's what that committee does. Okay. That's why we use Texas Real Estate Commission promulgated contract that we can find on TREC or on Texas Association of Realtors. Okay. National, no, because that would be national for all 50 states. Each state has their own documents, own contracts. When you end up joining a brokerage, you're going to have a software, a program that accesses all the contracts for you. There's different resources and not download them from TREC. Okay. All right. Number 85. So very good. Very good. Okay. 85. Who does a broker employ when signing a buyer representation agreement? Who does a buyer employ when signing a buyer representation agreement? A salesperson, B, a broker, C, a principal, or D, a consumer. So broker and oops, sorry. I got a kitty cat who wants to go out. Okay, type your answer. I'm going to let my kitty cat out. One of them. Outside? Don't go outside? I'm an animal lover, okay? All kinds of animals. But right now I have 2 cats and my neighbor's cat that comes to visit. Okay, B. Okay. C is not correct. It says, who does a buyer employ? Lisbeth, think about it. The buyer is employing whom to represent them? A seller employs whom to represent them? That's better. The broker, okay? Now, they may employ the realtor through, the broker through us, right? Because we're the associate that is with the brokerage, okay? The broker doesn't represent every single client directly, okay? But they own all the contracts, all the listing agreements. But we earn our commission, they own their portion until we cap, okay? Then we get 100%. Okay, somebody wrote 86B. We're on question 85. That's why I like y'all to write the answer. And so in Sook, I'm asking again, please type the question and number. Oh, you did. Very good. Thank you. Thank you. Sorry, I didn't see the second time. So very good. 85B. No need to apologize. Or, well, so did I, huh? I tell you not to apologize and then I do it. Ha, ha, ha. Okay, 86. I have fun with these classes, okay? Can you tell? And I've been doing these for almost 9 years now. Okay, but not on YouTube. All right, 86. A closing occurs on July 5th. Okay, this property closes July 5th means buyer and seller go into the escrow company, title company, attorney's office, and sign the documents. That's what closing means. That doesn't mean that's when it funds, but that's when they go. Closing means that's when they go sign the documents. According to the term, excuse me, according to the terms of the agreement created by using the Texas Real Estate Commission, known as TREC 20-6 form, which of the following statements is true? A, the buyer will be responsible for paying the ad valorem tax for July 5th. B, the seller is responsible for paying the ad valorem tax for July 5th. C, ad valorem taxes will be prorated to the day of closing. D, the seller will pay the ad valorem taxes for the current year prior to closing. So what are ad valorem taxes? They're on your property tax report, right? Excuse me, I need to drink some water. Again, type your question and answer on the chat box, either on Facebook or on YouTube. And if you haven't gone to my YouTube channel, hey, I'm going to say go to my YouTube channel, YouTube AgentPrep, and tap that subscribe button, okay? Send me some love, encourage me, give me some motivation to create more videos and do more trainings and other videos to help you get your business started once you pass your license, and how to go about choosing a sponsor. And like this video, okay? Oh, click that little bell, okay? You'll get a jingle, an alert when I go live. All right, so far, yes, property taxes. That's correct, Iris. So far, I've got 86BB. Lisbeth, I would, and Lou Lotta, I would do it again. Take another try. It is not C. In Sook, it is not C, okay? I keep looking over there because I'm on StreamYard, right? And that's where I see the answers coming in. But the camera is right in front of me. It's actually the computer camera, right? I have three monitors, a monitor to my right, a monitor to my left, and the monitor in front of me. So I get to look at your replies on the left. on the right. And I'm looking at what I'm reading right in front of me. Okay, so B, 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 C, C, C. No, we, no, C, C. All right, good. Y'all have changed it to B, and that is correct. The answer is B. The seller is responsible for paying the ad valorem tax for July 5th. Seller pays from the beginning of the year to the day of close. Buyer pays starting the next day, July 6th. Okay, so if the closing documents state July 5th, but they actually sign, a day later, the title company may not, it can cause problems that the lender has to change all the dates. So sometimes they can't sign the documents on the same day, but they'll still have a closing date for July 5th. And why? That impacts interest, the proration amount, and everything. So they'll still keep the July 5th closing date. Let's say somebody, didn't make it on time to the closing date, they'll close in the next day, and it'll still be considered July 5th, okay? Because at least one party signed on that day. So the answer is B, right? Better make sure I type the right answer. Very good, y'all. All right, number 87. Dave Gates, a widower, a widower died without leaving a will or other instructions. So without a will, with a will, which is which? His surviving children may acquire ownership of his real estate holdings by How? So a widower dies, doesn't leave a will, and they have he's got surviving children. So how can they acquire the property? A, adverse possession. B, eminent domain. C, escheat. Or D, law of intestate succession. So I've talked in other classes about how one of my students said, hey, Lillie, the way that I remember it is within, without. So within, without means if it's without a will, it can start with the word in. Okay, those that answered C, no. Do it again. Congratulations, Tiffany, for passing your national. Woohoo! Hey, I gotta show my cheering face. Okay, I get all excited. Woohoo! Congratulations on passing your national. Okay, that's the longest test. So I'm so happy for you. Keep studying the state. Okay, state questions. And you see, this is the state portion. There are still a lot of vocabulary on state. So learn them. So without a will is what kind of inheritance will the children gain it? Surviving children. How, it says, how may they acquire ownership of the real estate holdings? So far D. So those of you that answered C, no, it's not escheat. Escheat is if they don't have a will and no surviving individuals, it goes to the state. Without a will is intestate. Within, without. Without a will, intestate, within. Okay, so it is the law of intestate succession. Okay. Did I type the answer? No. But you see, you all, people that study and practice and go take the exam, they may pass one, they may pass both, and at least you now know what you have to study and prepare for. I'm so proud. Law of intestate. It's just intestate. Okay, Jen, and they put the law of intestate succession. So remember, within, without. Without a will, with intestate. Okay. All right. 88. When a salesperson leaves the association of a broker for any reason, how soon must the broker return the salesperson's license to TREC, Texas Real Estate Commission, and notify the salesperson in writing, okay, in writing, that the sponsorship is terminated? So how soon, when a salesperson leaves the association of a broker? So the salesperson says, hey, I'm leaving this broker. I'm moving elsewhere, or I'm getting out of real estate. How soon does that broker have to return the license of that salesperson to the commission, Texas Real Estate Commission, and inform the salesperson in writing that the sponsorship is terminated? Okay, so far I have A. And thank you for those that are sending love. Yeah, you can send some love on Facebook and on here, man. Send me some little hearts, some little love. And if you're watching on YouTube, hey, click the like button, okay? The thumbs up. I can't see it right now on here if anybody. I have several people on YouTube. So come on, click that thumbs up for me. Give me some love. There's quite a few of you on YouTube. Okay, and I only have 2 thumbs up. Come on, dude, chicks, ladies, gentlemen. And yes, the answer is A, 88A. Hey, you're getting free education here, right? The least you can do is give me a thumbs up, like the video, let me know that you love them, and let me know that you hate them. I won't erase it, okay? But I don't think you're going to say that. Wash hands, wash hands, wash hands. Yeah, immediately. Do it now, right, Laura? Do it now. So 88A, very good. All right, let's go to moving right along to number 89. Okay. Thank you for the love and the thumbs up. Okay, for doing that on Facebook. Also do it on YouTube. All right, I got, woohoo! I got 5 thumbs up. Thank you, thank you, thank you. Love it, love it. All right, number 89. A licensee avoids mentioning negative important facts that he or she knows to be true in his or her presentation to a potential buyer. Okay. Yes, I'm clapping. Oh, wash hands, wash hands, wash hands. She said she was clapping. Okay. It kind of made me think of COVID, right? What do we do as soon as we get home or anything? Wash our hands ASAP, immediately, right? And so that's how soon they have to return the license, immediately. Okay, 89. A licensee avoids mentioning negative important facts, negative, that he or she knows to be true in his or her presentation to a potential purchaser of the real property. A potential purchaser of the real property. So this licensee doesn't tell them about any negative important facts. Keyword, facts, right? So the licensee is what? A, may be charged with misrepresentation by omission. B, is practicing good business. C, may be in violation of the Truth in Lending Act, or they a lender. D, is only fulfilling his or her fiduciary duty to the seller. So a licensee avoids mentioning negative important facts that he or she knows to be true in his or her presentation to a potential purchaser of real property. Okay, it says potential purchaser. It doesn't say client or just customer, okay? However, what are we supposed to do with material facts, okay? Whether negative or positive, okay? But this licensee doesn't tell that buyer about these material facts. So what is that buyer is that licensee doing the right thing, or are they guilty of doing the wrong thing? Disclose, disclose, disclose. You got it, Iris. Yes. We must disclose material facts. If they're not visible, but we know them, okay, we know them, we are aware of them, we must disclose. Whether they're a customer or a client, and whether we're representing the seller, okay, on a listed property that we have. We still have to disclose. It's a material fact because the seller has to disclose those also. And so if we weren't aware of them, we read them on the seller's disclosures, right? Because seller's disclosures are required for individuals who live in the property, or they inherited, or they are aware of the condition of that home. So some people are exempt from doing seller's disclosures, but not those that own it, have lived in it, or inherited it. So yes, the answer is A. May be charged with misrepresentation by omission, right? They omitted important facts, right? True, negative facts. So very good. 89A. Yeah, I get a little excited about some of these things, okay? Because, you know, you might think, well, they're not going to find out, man. Oh, I'm not going to tell them. It's going to impact my seller. And hey, you know, I don't represent them, so I don't have to tell them. Wrong. Okay, wrong, wrong, wrong. Disclose, disclose. Okay, last question for the evening. Oh, I've got to reduce the resolution. It's a long one. Oops. Reduce a little bit more. Dang. Let's see if I can. Oops. Okay, I think I got it all on one page. All right, any questions? Let me see. No questions? Okay, very good. Okay, I'm going to show my face a little bit on here, okay? For those of you who may have come late, we are doing exam number 3 on the Texas state questions. You might be from another state, but at least you get to understand, you know, how to read the questions, how to think about them, and question yourself to help you answer, and to realize that vocabulary is very important because you're going to have some similar questions in your state. Okay. Last Texas state question. When a buyer makes a request to a seller to amend a contract during the option period and the seller fails to respond, what is the status of the contract 2 days after the option period has expired? All right, so there's a contract between the buyer and the seller. The buyer requested an option period. What is the option period? The period that the buyer has the right to do inspections without losing their earnest money, as long as they were to terminate within the expiration time, 5 p.m. on the option period deadline. Okay, so what is the status of the contract 2 days after the option period and the seller hasn't replied? A, the contract is null and void because the request to amend serves as adequate notice that the buyer does not wish to proceed. B, the contract is enforceable and the buyer is obligated to complete the transaction under the original terms and conditions. C, the option period is automatically extended until the seller responds. D, the contract incorporates the buyer's requested changes and moves to closing since the seller did not object to the changes. All right, so which is correct? Remember, both parties have to agree to changes. And an option period is the period that a buyer has a right to do inspection, do their due diligence, okay, and follow through with the contract or terminate it or negotiate for repairs, as long as they do it before 5 p.m. at the deadline. If it's a 10-day option period, they must do it before 5 p.m. because the seller has to be notified. First, the buyer agent gets notified by the buyer, then the buyer agent has to tell the seller agent, then the seller agent has to tell the seller. Okay, so if the buyer agent tells the listing agent at 4:59, and there's not enough time to tell the seller, it's past the option period. Okay, the earnest money is now at risk. Okay, so I've got, let's see, I've got A, B, B, A, B, A. It is not A. A contract is not null and void. Okay, just because the buyer asked to amend it. That is not adequate notice. That is not proper notice that the buyer doesn't wish to proceed. Proper notice is they must terminate. Okay, so it is not A. Those of you that chose A, think again and choose again. The contract can be null and void if it doesn't have signatures. Okay, it's not valid. Okay, it's not a valid contract if it doesn't have signatures and it doesn't have an executed date. Okay, once it has everybody's signatures and both parties have been informed by the realtors, and then the last realtor that gets signatures, they execute it, means they put the date. Now it's a valid contract. Okay, so we know it's not A, so it's either B, C, or D. And option periods are not automatically extended. Option period has to be paid for. A buyer has to pay money for the option to have the seller sit and wait, okay, for the buyer to do their inspections. During that period, the earnest money is not at risk because the buyer has to pay earnest money or some type of consideration, right? The option fee is money or a check or a money order. And that option fee goes to the seller, whether the buyer continues with the contract or not. Earnest money can be refunded. It depends on the conditions. Okay, so I've got B, 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 B. And it is not D. Who was it? Laura. Okay, it is not D. So the answer is B. The contract is enforceable and the buyer is obligated to complete the transaction under the original terms and conditions. So if the seller didn't reply, it's because the seller didn't like what the buyer was requesting. So in order for the buyer not to lose their earnest money, they would have to terminate, okay? Because they didn't get a response. They can't just wait. The deadline was option period ends at 5 p.m., whatever date was specified on the contract, which is now on the first page, okay? And if the buyer, although the buyer requested a change, but the seller didn't reply, the seller didn't sign, that means seller didn't like it, or maybe seller didn't get it in time, okay? Was out of the area. Well, that buyer better make a decision and terminate that contract if they don't want to lose their earnest money. They want to keep their earnest money. Okay? Because if they just sit on it and wait, that's where the buyer agent has to advise the buyer that, hey, seller's not responding. We need to terminate this contract so that you can get your earnest money back. Because if you don't terminate, then it means you accept the contract. The fact that the seller didn't reply is acceptance. Okay, so the seller didn't reply, the option period continues on. Okay, the control at that during the option period is with the buyer. So the buyer has the choice to let it go, which is not a good thing. Okay, a decision has to be made. So it is B. The contract is enforceable as it originally was written, and the buyer is obligated to complete the transaction. So now their earnest money is at risk, and so they've got to have something else, okay, in order to terminate that contract. There are a lot of areas in the contract that a buyer can terminate. In the lending process, in the appraisal, in the survey, if they don't meet the right requirements from the lending, there's a lot of, or if they don't like what's on the title policy, if they don't like what's on the survey, there's a lot of sections in the contract that a buyer can still terminate. Okay. So that was the last question for tonight that we reviewed and discussed the answer for Texas state questions. And that's awesome that there was quite a few of you on here. We had at least up to 13. You're very welcome, Laura. I enjoy doing these. Like I said, I've been doing these for almost 9 years. There was a time I only did them on Thursday, and then to accommodate some students, I changed to Wednesday. And I've had them on Wednesday, used to be at 5, but then some people are still working. So I moved it to 6 p.m. And it's been at 6 p.m. now for years. And then I added Saturdays consistently. I would do them on and off. Okay. So now, because I'm also on YouTube, and YouTube promotes my channel, the more subscribers I have, the more likes, the more time that you watch the videos, YouTube pushes my videos. And so my channel is growing. I'm now at 539 as of today. So as of this year, it's grown by 2. So the more people, the more comments that you can make, the more you watch the videos, the more it helps my channel. And so that's what I ask of you, is to subscribe to my channel, YouTube Agent Prep. Click that little bell. You'll be the first to get a notification when I go live or I post a new video, and like the video. And I appreciate all of you that like the video tonight. There are 7 of you. Those of you that are on Facebook, if you can go to YouTube, hey, and like the video, write a comment. Let me know what you think. Let me know what else you want me to review, and I'll make that for you. Okay? So, hey, you all, keep studying every day, a little bit, a lot, okay? And remember, the book that we used today was this one, Texas Real Estate Sales Exam, 4th edition. It is on Google. You can download it. It's also on my Facebook group, okay, that many of you are members of. Some of you that may be on YouTube, you don't have access through there, then you need to sign up to my Facebook group or send me a private message, and I can send you a form where you put your name and phone number and where you're from. I mean, you don't have to give me your phone number, okay, but it would be nice, and your email. And just know that I'm also a realtor here in Texas, and I'm looking for realtors to partner with me anywhere in the US and any other country. With the company that I'm with, eXp Realty, we are a virtual company, a cloud-based company, and we're all over the world, and we're now number 2. Okay, I moved from the prior broker. I've been with different brokers, and I had drank the red Kool-Aid, even though red and black are my colors, with the other company. However, during COVID, I realized that this is a much better company for myself and for my students and beginning realtors and those who want to make this a business and your way of earning multiple streams of income. Okay, so you're going to be looking for brokers. So why not also talk with me and find out what we have to offer? Okay, many people change companies. Okay, I've been at 5, 6 different companies because I've been in 3 states, and I like them all. However, some had better opportunities for growth, training, education, free coaching that others didn't. Okay, so any questions? See, I drive listening to your videos. Woohoo! I love it. Awesome. Hey, I listen to a lot of stuff while I'm driving. Okay, and that's okay, Luilata, that you got in late. The video is recorded. All right, everything that I go live, it's recorded. If I upload it, it's all there 24/7 on YouTube and also on the Facebook group. And say, I watch your videos on TV. Hey, awesome, at home and on my cell during lunch. That's awesome, Iris. Hey, and I wish you all from the heart, bottom of my heart, from my heart, okay, that you pass this exam. Tell yourself, I passed, I passed, I passed. Believe in it. Don't give up. Don't beat yourself up if you don't make it the first time, the second time, the third time. I failed the first time every time I took a test, okay? I used to get really nervous. And now there are techniques to test taking, and reading the questions the way we review them on here really helps breaking down the question. Of course, you don't have that much time on the exam, but that's why you have time now. And if you get a 60 on practice your exams or a 70, don't stop there. Keep taking the same test over and over till you score 100. That's what I used to do. I kept taking the test over and over and over until I got 100. And sometimes I would have to take it 3 or 4 times. I kept missing the same questions, right? Because we understand them better and we recognize them. When you repeat something, the questions over and over, and you're going to have questions that are not the same or that you've never seen or heard of on the exam. They're there to make you think. Remember, I learned from one of the books on prepping for exam, the first 5 questions of every exam are the most difficult. They're trying to get you nervous, trick you, and see if you can handle a difficult time, a challenging time, okay? If you can handle stress, because you're going to be dealing with all those situations when you're out there with public. You're helping people with their life, with their most precious possession. That's a roof over their head for their family, for their kids, for themselves. All right. And it's a very important decision. So it's very stressful for buyers and sellers. Okay. And you will need to learn, as I have, to get some thick skin and understand and do your fiduciary duty. And you are the professional. You're the boss of you. You're the one that knows the stuff on how to guide them and take the lead on helping them, because we're the one that know the market as we learn it. Okay. We don't when we first start out, but we learn it every day. Okay. With that said, hey, keep studying. Lots of love, lots of good luck, and take those exams and keep me updated. All right. Love y'all. Have a good night. Drive careful. And thanks for listening. Until next time. Catch you later.